After an accident, minutes matter. Your words and actions matter even more. You need help, and you need it now. This is David versus Goliath, brought to you by Dolman Law Group Accident Injury Lawyers, a boutique firm with a reputation for going head-to-head with the insurance company giants and putting people over profits.
Welcome to another episode of the David and Goliath podcast. I'm attorney Matt Dolman, managing partner of the Dolman Law Group, here with my esteemed business partner, Stanley Gipe. And we're lucky today. We have a real legit trial lawyer, aside from Stan. This guy's better looking, though. His name's Brendan Lupetin. He's out of Western Pennsylvania, out of Pittsburgh. We don't get a lot of Pittsburgh guys on here, and I fucking hate Pittsburgh simply because I'm a University of Miami guy. I'm an ACC guy, and Pitt usually kicks our ass. Not a big Charlie Patridge guy, but I'll give you the fact that you guys just have Pat Narduzzi just owns us, and I'll just leave it alone from there. So I'm jealous of people from Pitt because you generally have much better teams hockey-wise, football-wise, and I'll shut up from here. So we brought Brendan on this morning. Stan wanted to discuss a little bit about business litigation and med-mal. Stan?
Yeah, Brendan, I'm glad you came on because we get a lot of attorneys on here, and we do a lot of stuff on medical malpractice, a lot of stuff on negligence claims, and really it's the damages that change, the fact patterns tweak a little bit. We don't have anyone on that's really talked about contingency fee business litigation, and I take a little bit of an interest in that because, I was saying to Matt, everyone has business litigation issues. Everyone has breach of contract issues. Most of us don't address it. Right? I mean, how many times do you buy something with a 3-year warranty that breaks in 6 months and you just throw it away because it's a $10 item? I mean, technically that's a breach of contract issue, not worth pursuing. But on these bigger issues, right? If you get in an auto accident, no one wonders what you're supposed to do, okay? No one wonders how to get an attorney. It's almost hard to avoid an attorney in that scenario. When you got a business contract issue that you can't afford to litigate, the walls can feel like they're closing in on you a little bit more, and the options may not be as obvious, right?
Yeah, I couldn't agree more, and I think it's kind of a sort of a two-way street of how do all of us as more toward a sort of personal injury contingency fee lawyers. How do you find those clients on the business litigation side, and on the other side, it's the business entities that are potentially great candidates for a contingency scenario. It's literally like it's like a foreign language to them, the idea of contingency work. So, it's sort of a fluke a lot of the times that we pick up business litigation, and we mostly do medical malpractice. We do, some catastrophic personal injury stuff as well. But, for me, variety's the spice of life. And so have had an opportunity to make relationships with what I find are these mid-size, typical business transaction type law firms. And they have all these different clients, all these different business clients that are just, all they know is the hourly format. And if you can just plant the bug in the ear of some of the attorneys over there to say, hey, if you ever have a client who's got a legitimate claim, but for one reason or another, the idea of, a big upfront retainer or just high, consistent hourly fees that they're never going to get reimbursed is not appealing to them, I'm here, or other firms like me are here as a possible option, a contingency option. And what I've found is some of these clients, when they're, it's pitched to them by a lawyer, one of these firms, they're bowled over. They literally can't believe that a lawyer would take their case, and they're like, wait a second, so you'll do all the work, you'll do everything, invest the money, and obviously, everything depends on the type of agreement that you sign with them, and then you just get a percentage of it at the end. I mean, that generally speaking, they've been just shocked that firms like us would do that, and so it's worked out really well. So I think the key is first, just getting into the ear of the lawyers that they're more likely to be speaking with, because I don't know how you're ever going to really be able to market to businesses in general, that you could ever, hey, if you got a breach of contract, call us for contingency work. I just don't think it works that way. So I think the play from a marketing perspective is to, make relationships with lawyers at these, mid-size business firms, the kind of places that would never hire me back in the day. And then just, continue to remind them that you're an option there. And we've had a handful of different cases that have spun off And, you got to be very choosy, I think, with the cases that you take on, like any other case, but you really have to scrutinize them. What you also find is that the business owners are very savvy. They're smart. They really analyze the agreement that you provide them. They're often trying to come up with, different alternatives and so forth. And I can talk to you about a bit of a pitfall. I mean, it's kind of a good pitfall to be in, but on one of the first business litigation cases I ever handled, if you guys want to hear about it.
Yeah.
All right. So, as more of a puppy lawyer, this is, I'm maybe 6-7 years out of school. A local company just gets completely screwed over on a product. And the gist of the case is that for a lot of products that are sold in the United States, you have to have certain testing certifications. So you have to take your product, you have to have it examined by a third-party testing agency. And on the back of pretty much every product you see, smoke alarms, toasters, stereo equipment, you'll see stamps on the back of them. Sometimes it's CSA, UL, you'll see is a super common one. And then there's another company called Intertech, which is a huge player. And in my estimation, it's kind of like the discount third-party testing agency. So this company has these space heaters. They're vent-free wall heaters. They land a big contract. The heaters are manufactured in China. But in order to continue selling them, they've got to get approval by a third-party testing agency. Here comes Intertech. They test them in China, and the company gets the seal of approval. These things are good to go. Okay, you can sell them. So they start selling them. They're selling like gangbusters at Ace Hardware, Home Depot, etc. And one of the competitors of the company that I represent gets pissed. And so they buy one, they look at them, and they figure out that, in fact, the product, these vent-free wall heaters do not meet the safety certification. And so then they report it. They tell everybody. And Intertech goes back and looks at them and says, oh, yeah, you're right. They aren't. And they just basically throw their hands up and say, oh, sorry about that. Too bad. And it costs the company in question a lot of business. And they go, the owner of the company, a good friend of mine eventually, goes and talks with, business lawyers, and they're just kind of not interested. And he's not really in a position to pay significant hourly fees. So the only pitfall I would say is that, this was early in my career. So what I did was I signed a 40% for the first $500,000 recovery, but then it tiered down precipitously after the first $500,000 because I'm thinking to myself, hey, if we got a $500,000 recovery, that would be incredible. That would just be amazing. And hey, everything after that's gravy.
Oh man, 6.3 million.
Yeah, with interest, there was another basically million on top. So I mean, it wound up settling because it went up to the Third Circuit and was upheld. And I mean, it was like 7 something at the end of the day. And after I think it basically the overall fee was wound up being about 11% or 12% instead of 40%. But I mean, it was a lesson to learn, and it's something to consider as us attorneys. If you're interested in looking at business litigation, you have to kind of plan for the possibility of a great outcome, but also I think at the same time be, willing to accept, like, do I want the bigger chunk up front versus, I'll take the risk that it's less likely to get that massive recovery and, you can live with it. And believe me, I was, it was a great day just to get that verdict from everything that we went through, but definitely something if you're a personal injury contingency type lawyer like most of us are, and you're looking to get into that business litigation, you just as much as the other side has to really think about how do you want to structure your contingency fee, because a lot of times, savvy people on the other side want something a little bit different, and they're good negotiators on that point.
Yeah, interesting. We didn't start hearing about contingency fee business litigation until probably 2011, 2012, when Morgan & Morgan started their small business group. And I agree with you, by the way. Advertising to personal injury clients is a lot different than advertising to businesses. It's probably looked at as a little lowbrow. So relationships really have to start at the business level and be very granular of who you meet. I always wondered how you get that type of practice to take off, but we're here in Florida where we just got slammed with tort reform, and it's awful. I mean, forever Florida lawyers are pounding their chests about our big verdicts. I know before we got on, we were talking about Los Angeles County and the runaway verdicts there. Florida was a close second, and now we're one of the worst states. And this might be an area we start to segue into over the next couple of years. There's not a lot of lawyers that do this on a contingency fee outside of like the massive firms like a Morgan that does it in a Walmart model, if you will.
Well, so I'm curious. I mean, you guys are down in the epicenter of Morgan & Morgan and territory, and they're up now in Pittsburgh and causing a lot
They're
of
everywhere.
Yeah, yeah. A lot of discussion amongst the the larger PI shops around town. But I remember hearing John Morgan talk a while ago about the importance of planning for black swan events and diversifying your practice and so forth. And he was really bullish. I mean, this was probably 7-8 years ago on that contingency fee business litigation. But I haven't seen how they market for that. It's not like I've seen billboards or advertisements, directed specifically to business owners. I don't know if you guys have in that regard.
No, it's almost like cross-selling. They put out, they're everywhere.
Yeah.
They're omnipresent. So in their newsletters, if you look at, and he does an email blast also of over 100,000 subscribers, he mentions the business litigation in there, just like he mentions the mass tort, but you don't see them advertising for either. It just comes in ancillary to their personal injury practice. If you will.
Well, there was a Stan. Do you want to say something?
Yeah, I was going to say he has run a few spot commercials that I've seen where he's, really advertising for the contingency fee business litigation, but they're really, really sporadic compared to with the other stuff he runs. My question to you a little bit, like if someone comes in auto accident and says, hey, I'm rear-ended by a target truck and I'm paralyzed. Well, you don't have to do much investigation to know that's a claim you want to get out there, you want to sign up, you want to take, and you want to run with it.
No doubt.
Okay, someone comes with you and says, hey, somebody did a bad job, testing my space heaters in China, and now I can't sell them here. How do you prepare, what do you do to get up to speed to be able to make that sort of first decision on a case? Because it's not going to be quite as intuitive as, your cookie cutter auto stuff, right?
So I agree 100%. And I think that, my practice is predominantly medical malpractice. I'd say probably 75 to 80% of what we do is medical malpractice. And med mal is sort of analogous, I think, to the investigation that you have to do in the business litigation type cases, because you really have to do your legwork. As you just said, target truck smashes in the back of a vehicle. You pretty much know for certain that's a great case that you're going to jump on no matter what. Med mal cases, you've really got to do your due diligence. I mean, there's the occasional case if it's a wrong level surgery, wrong body part, or just some total catastrophe, then for certain. But almost all the cases we have to really dig in. We have to consult with experts, and we got to start with the records. The medical records are the bedrock foundation piece of evidence in med mal cases. Similarly, in business cases, you've got to collect all the documents, and you've got to keep digging in with the client. Give me the contract, give me all the emails. You got to do the email searches. You have to go through everything and really piece it together to make sure that you have, all your ducks in a row, basically. I'll give you, 2 examples. So on the space heater case, we had to go and then have the client go back and request all these different documents from Intertech, all the testing documents. And then we would read them, and there would be a reference to another document that was, a part of it that they didn't have. They had to request that. And you had to just keep tugging on all these different threads until you really felt that you kind of had the universe of documents that the case was about, and then start to put it together. There were some very egregious things in that particular case, for instance, and a lot of it had to do with language barriers. So you had Chinese, like in Guangzhou, China, engineers interpreting English written standards to the products in question. And they were literally testing this guy's wall heaters as if they were grills, like food grills. And it literally said there, like open top grill, you know what I mean? All this like ridiculous stuff that just had that kind of shock factor that I was like, I think there's something here. In another example, the truck company, local truck company, gets an excess verdict. And they go and talk to a local business group about, the implications for them, ruined the company. I mean, just really, they were running on such a tight margin at the trucking company. This excess verdict essentially, ran the company out of business. And so the proprietor, former attorney himself, goes to his, longtime business, law firm and says, hey, I've got this case. Will you guys handle it? And they're like, it's going to be, here's our proposal. Here's the retainer, here's the hourly. He said, I'm really not in a position to handle that kind of case, to take that on right now, given, that's kind of the reason why I'm talking to you is because I've been financially ruined. They say, hey, we know this guy, Brendan, he does this kind of work on a contingency. You might want to talk to him. So we talk, again, have to dig into all these records. We go out to the trucking company. We dig through all these boxes of papers of different documents that they'd gotten from their insurance company, all the different, underwriting policies and all this different stuff, all the communications. You have to gather all of that, just to make sure you really have, all your ducks in a row before you get going on the case, because there are so many potential pitfalls in them. You got to be really certain that you're going to have a pretty strong case before you move on it.
Let's dovetail for a second to MedMal. So, and to educate those who are listening to this or who will eventually listen to this, last year as a firm, we took in 3,700 MedMal leads. Guess how many MedMal cases were signed up?
I mean, if it's anything like our case, our situation, Matt, I'm going to guess like 95% of those were not cases, something in that realm.
More. We signed up, when I say we signed up, we don't do MedMal here, so we refer it out.
Yeah.
7 cases were signed up.
Yeah. I mean, and that's the right ratio, honestly.
So 1 in 530 or 540, if you're a math geek, were signed up. I just want to make sure people understand it's going to be best coming from you. How difficult, MedMal cases are, because 70% of MedMal cases, at least here in Florida, end up as defense verdicts.
Yep.
2, it's not generally medical malpractice. It's hard to prove a doctor truly deviated from the normal standard of care or the expected standard of care of a like-kind physician. Often it's just bad outcomes.
Yep. Yeah, I have a lot of thoughts on this. So number one, and I think it's a truism, people believe, they want to believe, they should believe that overall doctors are nurses are trying to do the right thing. I mean, they're trying to provide the best care possible. Now, does that mean egregious mistakes don't happen? No, they happen all the time. But that overall belief system, and not just the truism that I mean, my dad's a physician actually, and I know that doctors and nurses are trying to care. But people also want to believe in a just and safe world. They do not want to live in a world where this horrible thing that happened to this person could just randomly happen to themselves as well. There's cognitive dissonance there of imagining that. So it just makes the hurdle that our clients have to overcome to prove the case, to show that this was a really unskilled or a really uncaring doctor in this particular situation is just incredibly difficult. Not to circle back to Eminem again, but Keith Mitnick has said before that of all the cases he tries, the tobacco litigation is that's the most difficult machine case to try against, but the most difficult cases to win are medical malpractice cases for purposes of getting a verdict. So I mean, you really have to limit the cases to that real outliers, catastrophic damages, or everything's kind of on a, like a related continuum. So if you have just slam dunk admitted liability, then you may, be able to take a case that doesn't have like absolutely catastrophic or wrongful death type injuries. But otherwise, you pretty much have to start your analysis with massive damages, horrible outcome, and then reverse engineer and then look back and say, okay, now was there something that could be said that this wasn't just a consequence of the illness or the medical condition or so forth, and then you backtrack into, is there a legitimate theory of liability here? I think that's kind of the way you have to look at it rather than the other way. And so, yeah, you're right. I mean, it's just you're gonna go out of business quick if you just take on too many questionable med mal cases, because they fight them like crazy. It's difficult to convince most people that that the medical profession was not doing what they were supposed to do under the circumstances.
So we have a $10.8 million verdict on a very obscure case. This involved a allergic reaction, if you will, during an MRI procedure. Tell us about this case. It's usually the obscure, weird, strange factual scenarios that create these humongous verdicts. If you ever look at big verdicts on different law firms, especially MedMal, it's not the stuff you would ever market for if a MedMal case. You wouldn't expect that. It's odd. I've never seen that factual scenario.
Well, and haven't you guys also seen this in almost any of your cases where that result in a great verdict? It's almost always because somebody on the other side misassessed something. They misevaluated the case. They got locked in on a certain view early in the case, and they didn't change it with new information or things that they couldn't. There was some big misevaluation, and this case was a perfect example. But there's something else here, for the med mal or the potential med mal practitioners that I think is really important to keep in mind for med mal cases, okay? So the way I do focus groups all the time, and what I find is that, and I think it's a legitimate thought, is that most people are looking, okay, well, what actually caused this person's injury? What actually caused this person to die? So let's think about the example of a delayed diagnosis of lung cancer case, and I'll get back to the verdict in just a moment, but it ties directly to this. So you have a case where the radiologist just blatantly missed a treatable mass on an x-ray, and the patient goes on for no treatment, delayed diagnosis 2+ years. When it's finally diagnosed, it's metastatic, it's untreatable, and they die from the cancer, okay? So jury goes back and they look at it and they say, well, that person, whether it's kept out or it gets in the case, so they were probably a smoker. They're either going to assume it or they're going to learn that the person was a smoker. So they're going to say, okay, that plaintiff partly caused this to happen by smoking. Everybody knows smoking's bad. It can cause lung cancer. Number two, they're going to think to themselves, that person didn't die. The doctor didn't kill them, okay? The tumor killed them. And it's a simple distinction, but people think about that. And so you have to overcome and show that, no, I'll use sort of the dominoes with the hand blocking the dominoes and show that proper care would have prevented this from happening. But the underlying concept makes it really difficult that in those cases where there wasn't a surgical intervention, they cut the wrong thing, they operate on the wrong body part, they physically actually cause the harm as opposed to preventing it, which the vast majority of med mal cases are some version of failure or delay to diagnose. In almost every setting, that's like 80% of the types of med mal cases that you'll see move forward. Those are just naturally tougher cases because there was an underlying medical condition that was at play and typically played a big role in the terrible outcome, not just the doctor's actions or omissions. Which brings me back to why I felt that this contrast case that we tried in this outlying Blair County a couple of years ago during the heart of the pandemic, actually, one of the factors why we won the case. So the short of it was early 40s-year-old guy, bad back, but otherwise overall healthy, had a good job, and goes in for a routine MRI for his back just to check, see, does he have a disc herniation or a bulge or something that can be treatable to explain his back injuries. And he goes in, and as they oftentimes do for a lot of radiology studies, they inject him with contrast. And it's well known that in a very tiny percentage of the population, people will have an allergic reaction to the contrast, and they'll have an anaphylactic reaction. You've got to be prepared as a hospital, of course, to treat that patient, and anaphylactic reactions are typically very treatable. It's no different than my son has a peanut allergy, for example. You got, Matt, you've got the EpiPen, you know what signs and symptoms to look for, you got to timely treat and then get him over to the, hospital if the Epi's not seeming to work and so forth. So this place, they inject him. He has an obvious allergic reaction, but because of missteps that had occurred in the years prior, they have no medications nearby. They have no proper system for notifying people to come and help. And so he basically just caused to have a reaction. Nobody treats him. He lays on the bed and eventually arrests in the MRI table before people finally get there and take him down to the emergency room. But by then, while they're ultimately able to resuscitate him, he suffers a pretty significant brain injury, not able to work. He's kind of like the guy from Memento, if you saw that movie, where he has essentially memory for 5 minutes. And so you meet him, he's like your best buddy, seems totally normal. You leave the room, you see him a little bit later, he has no idea who you are. He has long-term memory, has old memories, but he can't form essentially new memories. Very eerily reminiscent of that. But so, I can explain some of the other, they had policies that said they were supposed to have everything to treat anaphylactic reactions. They had a call bell in the MRI suite that was supposed to, if you hit it, sound an alarm in the emergency room, but nobody had been trained in the emergency room about the alarm. So when they heard it, they didn't know what it was. There was a doctor literally testified that he had his head up in the ceiling trying to find where the sound was coming from because he'd never heard it before. Just this real circus. And my client, unfortunately, paid a very significant price for their negligence. there was a lot of different factors that played into why that case was successful, but one of them that I focused on was, and even though this wasn't negligent, they were the ones that caused his reaction. They injected him with the medication, and they didn't prepare themselves for what they knew was a potential dangerous condition, which was an anaphylactic reaction to the medicine. And so even though they weren't negligent for, administering contrast, I felt that it played a big role in the jury believing, well, hey, you caused this to this person. This was not just the person that had a heart attack because they had long-standing atherosclerosis of their heart. This guy was not going to have this reaction, but for you injecting him, you knew there was a risk of injecting him, and then because of gross policy violations, you did not intervene to keep his reaction from hurting himself. So, with you guys getting as many, calls as you do on med mal cases, I would suggest putting that in as sort of like as a criteria as you think through it. Is there something where the hospital system, the doctor, the nurse, directly contributed to the injury as a part of just not intervening or doing something in time or the right way? I don't know if I've gotten that across, but I just really think it's a really important concept to keep in mind when you're thinking about taking a med mal case and how you work the case up.
It's an interesting verdict. I mean, the closest I saw to that is, it's not, I guess the analogy fails, but it was a $31 million verdict out of Vegas by a lawyer named Christian Morris. I don't know if you know her.
I think I saw that. That was like a couple years ago, right?
A couple of years ago.
Yeah. And that was an allergic reaction case, I think.
Allergic reaction case. The medics failed to, in their jump bag, they eliminated a certain, I would assume it was EpiPen, but something from their bag that was, they saved, I just looked it up, $2.42 a bag by eliminating this. And somebody had an anaphylactic reaction and died as a result, and they didn't have the life-saving medication. And Vegas, by the way, when you compare verdicts, it's another, I wouldn't call it plaintiff hellhole, but it's close to it. It's the verdicts coming out of Vegas are disproportionate to what we see everywhere else in the country. Having said that, she's a great lawyer, but somewhat similar to your situation.
No, you got you got Ben Cloward and Sean Claggett out there.
Yeah, Ben Cloward's a good lawyer. Yep.
Yeah, just all gotten some monster verdicts. So, I think it was a confluence of things. And the interesting thing on that case in Blair that we got that verdict on was zero offer. It was a zero offer case, and my partner Greg, who had really worked the case up, asked me to come in and try it with him towards the end. And I'm looking at the case, I'm like, this case is good. This is a really strong case, and but I think you guys know as well as anybody, you still have to get a lot of luck, a lot of good fortune has to fall your way to win a verdict, even with a bad analysis on the other side. I think they made a horrendous analysis on not trying to offer something because the family would have taken a fraction of what we ultimately got, to settle the case. But one of the tricks of that case is I'm sure you guys have handled these different TBI type cases and so forth, where your client looks fine, look totally fine. And maybe
those are the toughest cases.
They're so hard, 100%. We were just talking. We got a decent verdict on a concussion case recently, but we had good objective evidence. But there's still that worry, and I think it kills a lot of those cases when the person looks fine. Okay, that was a big problem in that contrast reaction case because our client, like I said, if you met him, looked totally normal. And he could converse pretty normally. He even, I'm trying to remember if he did a deposition. He didn't do a deposition, but he could have, for sure. So defense counsel, of all people, moved to preclude him from the courtroom because they were worried he had some sort of explosive outburst at time because of his brain injury. And the lawyer, understandably thought that, it just would be too risky to have our client. Maybe they were worried that if he had an outburst, it would make it, it would underscore his injury. But meanwhile, that was the greatest, one of the greatest things for us because now my client can't even be there. And we can, credibly say to the jury that, it was decided by all parties that, essentially our client was not well enough to be in the courtroom. And now, instead of, they see the pictures, but in their mind, they're imagining, oh boy, like this guy really must be a mess and really needs a lot of help. And now they're just hearing all the different anecdotal stories from different members of his life and so forth, that really underscored, I think, the extent of his injuries.
That was a little bit of a miscalculation by the defense.
Yeah. Oh, I mean, but again, you have to get lucky. Those different pieces
I
have
don't
to
believe in
kind of.
luck. I mean, there's a little bit of luck in everything, sure, in happenstance of why you're in that circumstance. But as
No, you
the
make
old
your own
saying
luck.
is, you make your own luck. Luck is where opportunity meets hard work, and you guys
Yeah.
clearly are good lawyers. And you're young. I mean, you're a young guy. I'm 46. I'm not sure how old.
I'm
I think you're in the
same
same
age as you, man.
Yeah, and
I'm
you're a member of
same age.
ABOTA. So for those who don't know what ABOTA is, that's the American Board of Trial Advocates, and that's a pretty significant distinction for trial lawyers across the country. That's the milestone I think that every big trial lawyer wants to achieve towards being a member of that organization, which basically says that you are a preeminent lawyer in your area, that you have tried a lot of cases.
Yeah, I mean, just not to go on a whole backstory, but when I first started out, I started at kind of a circus-like firm, and wasn't making any money, but quickly saw the value was that I could try as many, sort of bad cases as I could get my hands on, and so I got to try dog after dog after dog, and got my ass handed to me many, many, many times, but improved just comfort level with that feeling of being in trial and so forth. And, realized I was making progress and eventually was going to get there. And actually, it's funny that we go down that path because that heater case, which was like 11 years ago, was my first really big verdict. I just remember I was like, when they read the verdict off, I started crying. I mean, I kind of cringe now thinking about that, but I was just so I had lost. I mean, I'd probably by that time tried 20 something cases at that point to verdict, and had a couple just measly verdicts. I had a couple, maybe one or two low six-figure verdicts and stuff, and to finally get what I felt was a good one in just a really brutally fought case. It was exciting in that sense.
It's a huge verdict. Were you crying? Was that for satisfaction or for the 11% fee?
I didn't realize. I hadn't done the calculations. I cried later.
You still did very well on that case.
No, it all worked out.
I mean, you said
well.
you'd be happy if you got over $500,000, so your fee was close. I mean, it's still a great fee. That's a great job.
Without a doubt. I mean, I'm not crying.
Well, a big portion of that was some punitive damages, correct?
Yeah. It was most of it. I think it was something like $750 was compensatory, and then 5 plus was something. No, it was like 1.25 was compensatory, and then 5 million punitives. The brutal part about it was a 2-day trial. The jury deliberated for 2.5 days, and it was just it was sickening. And they had question after question after question, and you couldn't. Sometimes you get the questions and you're like, oh, we're like, for instance, in the contrast case, the first question was, can we see the life care plan? And the second question was, can we have a calculator? I'm like, okay, I'm feeling good about this one. But that one was just, it was gut wrenching, to wait. But it was worth it, and we all have stories to tell now.
So how's your client sitting there? He's a businessman. He's not necessarily like an injured person looking to be right. I mean, this has to be like a windfall for him all of a sudden.
It was a windfall for him. But the funny thing that I find with business clients is that I don't know if they're more pragmatic than me or what, but they are very sort of matter of fact when the case settles or the verdict comes in. Like, he was obviously, overjoyed, but he was much more like, well, of course, they totally screwed me over. And I'm sitting there thinking, like, you don't realize how unusual this is. Like, this is crazy and so forth. But on a number of other cases, subsequently, the clients were very appreciative. They were very appreciative of a job well done, and, that we had worked hard on the case. But it was much more like, on to the next, business transaction or aspect of the business and so forth. So, the client in the space heater case has parlayed that verdict into a lot of great things. So, it's good to see that way. But it's funny. I think the reaction from people that have been personally injured, physically injured, you see a lot more of that. Well, hopefully, the joy and the tears and so forth when the resolution of the verdict comes in.
What does the next 5 years look like for you? Because you built up a nice reputation as a trial lawyer. Your practice has expanded. You've had a lot of recent successes. Are you going to stay just in Pennsylvania? And this isn't a pejorative question. It's not. There's no bad, answer to this. Are you going to become a national trial lawyer where you pro hoc into different states and want to take looks at the biggest cases? And because there's a lot of guys that do that. So some of the even names you mentioned earlier, like the Claggets and Clowards, they'll they'll pro hoc into different states and based on referral relationships and have a local counsel taking a small fee, and they can take a look at cases anywhere in the country. It gives you an ability to reach anywhere.
So I've thought a lot about that, and you never say never or make absolutes. However, probably 7-8 years ago, I started to think to myself like, oh, maybe I'll be one of these national type lawyers and jet set around the U.S. trying cases and so forth. And I got into it was actually the trucking business case, and it had me taking depositions all over the country. And this was before the real advent of Zoom. And I quickly realized that I did not like being away from home, being away from my wife, my kids. I just not designed to travel like that. And that probably in of itself was the number one decision factor that, we pretty much focus our practice on, from Harrisburg to the west of Pennsylvania. That's about as far east as we'll go. Other cases we're going to refer, and I wrestle with the idea. I mean, you guys are, just clearly, bigger and bigger, 3,700 potential leads for medical malpractice in of itself. I mean, that makes my head spin, to imagine the volume that you guys are able to generate. We're small, and I think we're probably going to stay small. I got my partner. We have a wonderful associate bringing on, another young lawyer. I mean, it's the, $64,000 question. Do you grow? Do you stay the same? Do you stay really small and so forth? And I'm sort of looking at the legal landscape these days, and it strikes me, for Pittsburgh in particular, that staying small, lean and mean is probably, especially factoring like my life balance and so forth. Like that's probably where I want to stay, and if people want to, bring me in to try a case within counties surrounding, I'm happy to do that and so forth. But yeah, I don't think I necessarily aspire to get too big.
You'll go to Philly, though. You'll go to the Philadelphia Court of Common Pleas to go try a case. You will, right?
I mean, if somebody wanted me to go try it, I mean, if I had the right kind of case. But honestly, Matt, that's getting a little far from home for me. I'm telling you, I'm a homebody, and
I hear you. Same.
But I do. I mean, then Zoom came in, and then you can take. I pretty much do all my depositions via Zoom and so forth. So.
I just see the verdicts coming out of Philadelphia. I'm like, oh my God.
No, they're insane. I mean, there was a $189 million birth injury verdict last year, and I just don't think that. Again, I mean, anything's possible, I suppose, but I think a good example is Shane Inspector, super famous lawyer from Klein Inspector, mega super firm from Philadelphia. He had the largest verdict in Allegheny County, which was $105 million for this, electrocution case, which was, obviously a fantastical outcome, a lot of punitive damage and so forth. But pretty much everybody believed that, had that case tried in Philadelphia, it probably would have been like $1 billion verdict, Mm-hmm. So it's, there's a lot to be said for that, but I'm okay just being the local Allegheny County, Pittsburgh lawyer, keeping it close to the vest.
You seem to be doing fine. Are you going to expand to any type of product liability or mass torts, or are you going to keep it to where it is right now with business and med mal?
So variety is the spice of life. So I'm trying a quote good slip and fall up in Erie County in September. So I like to try a smattering of different cases. We do product defect cases. We'll do medical defect cases if it's the right case, but we keep a pretty low volume of cases, try to keep the cases sizable, large value where we can really pour ourselves into the case to maximize the outcome for the client and really feel like we're, bringing a lot of value to just a small number of cases. For me, I discovered that I just don't do well with a volume practice. My prior firm many, many years ago was much more volume, and I just felt like I was constantly just kind of paddling, trying to keep my head above water and not really providing as much help, but it was when I'd find that one case here, the diamond over here that just kind of connected me and I'd really go all in on it that, for me, it just resonated more like, I don't know, with, I guess my simple mind. I need to have like one or two things to focus on. I can't balance too many, spin too many plates, I guess.
Gotcha.
Yeah.
Well, I appreciate having you today. I mean, that pretty much wraps up our discussion. I mean, I can keep you on for another half hour bouncing off topics off you, and we're probably going to have you on again, but I think we've kicked the proverbial tires on med mal and business litigation. I mean, we need to get out there and meet business owners, because that's probably the way to go if we want to segue into that area.
I think that's it, honestly. Yeah, Stan, what were you going to say?
I feel like that's a super interesting area of law and kind of a little bit underserved, to tell you the truth.
I just don't, with the reaction you get from the business owners to the concept that someone would work on a contingency, I think it's still to this day and probably will remain that way because of the difficulty of direct marketing, sort of an untapped great opportunity for cases. And I think, again, the takeaway for anybody listening that wants to get into that is you got to go make connections with attorneys that are meeting those type of clients in that traditional sense and just put it out there that, hey, this will always be your client. I will never, I will represent them in a one-off matter on a contingency basis, but they're always your client. You just look at me or our firm or your firm as, another service option that you can provide that customer, to give them the best experience or best, results possible and make it known that you're out for their best interests. I think that's the best sales point. And as long as you get touches on people and let people know you do that, I have no doubt that firms can pick up business cases on a contingency basis.
Yeah, and I agree that the advertising itself is probably lowbrow for a business owner, especially when
Exactly.
they see like a volume shop thing and be like,
How do
I
you
don't want
even
some ambulance chaser. We have that stereotype and stigma already.
Yeah.
You have the battle of consumers. They're not going to want to sit there and look at that and ugh.
And there's so many different, med mal or car accident or what. I mean, you can slap a big label on it, but how do you just slap on, business litigation? It's just, I don't think it's going to resonate because there's so many different, a lot of them are breach of contract or some variation of that, but I just don't think it's going to connect with most business owners. I don't think they'll even listen or even hear the commercials, quite frankly. It has to come from someone that they know and trust.
The other segue I'll leave you with before we just get off is I'm seeing a lot of plaintiff firms, not a lot, let me rephrase. I'm seeing a few plaintiff firms nationally jump into suing stockbroker loss cases, which I guess falls in line with business litigation. It's just another area of business litigation.
Yeah, definitely. I mean, there's an area right now that I think could actually, I haven't handled one of these cases yet, but the gist of the case is essentially, some type of class action. I mean, it's more for the consumers, but people who were led to believe they were in high interest bank accounts and the banks don't actually increase your interest rate along, but they're advertising that you're in a high interest bank account. And but you don't, get the value of that because they don't change the interest rate, unless you go back and unilaterally make sure that your money's getting into the high interest account. I think there's a big potential misrepresentation claim there against banks. I mean, I'm sure that they've probably, written in exculpatory clauses and so forth, but just something to keep in mind. But sort of like dovetails with, but kind of dovetails with all the financial advisor type, actions you're talking about.
Gotcha. Well, I appreciate your time, Brendan. That was really, it was a pleasure.
Thanks, guys. It's a great podcast. I've enjoyed a ton listening to them. I appreciate you having me on to blather on and ramble for a bit. So thanks for hearing me out.
I wish Pittsburgh a shitty season. I hope they go 3-8 or 2-9. I kid, by the way. You guys are like the cornerstone of the ACC now, especially if Clemson leaves and Florida State leaves. I mean, it's Pitt and Miami, and we suck. Miami
it's all going to turn into one. I don't know, two. Of these,
super conferences.
Yeah, I mean, at the end
you guys
of the
are going to be
day,
like in the Big Ten probably because that kind of it's just similar. I mean, you have
right
Rutgers
in the
Big Ten.
Yeah,
it's better
exactly.
than Rutgers.
Yeah,
so,
no doubt.
That's my thought.
We'll see.
Well, appreciate having you.
Thanks, guys. I appreciate it.
Thank you to our listeners, and I wish everybody a great day. Thank you again.
This episode of David vs. Goliath is over, but your journey is just getting started. To share your story with us, visit dolmanlaw.com. That's DOLMAN law.com or call 866-965-6242. The insights and views presented in David vs. Goliath are for general information purposes only and should not be taken as legal advice for any individual case or situation. The information presented is not a substitute for consulting with an attorney, nor does tuning into this podcast constitute an attorney-client relationship of any kind. Any case result information provided on any portion of this podcast should not be understood as a promise of any particular result in a future case. Dolman Law Group. Big firm results, small firm personal attention.